at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think...
Today we're diving into the saga of Mr. Valentine, a self-declared sovereign citizen whose courtroom appearances show exactly why representing yourself can be such a disastrous idea. This video collects several of his hearings to give you the complete story before his upcoming jury trial. From the start, Valentine refuses, an experienced criminal defense attorney, claiming that only he has his best interests at heart. The judge gently warns him how risky that is, but he dismisses all help. He seems to think that being sui juris means is above needing legal training. This is classic sovereign citizen strategy, rejecting expert advice while insisting they know better. But the courtroom is not a debate stage. It's a formal process with rules and consequences. His stubbornness turns basic scheduling into an argument over constitutional philosophy. Watching this unfold reveals why courts have to balance respecting defendants' rights with maintaining order. Even when given every chance to reconsider, he doubles down, showcasing how ideology can blind someone to real legal danger.
The prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial service.
Valentine's first hearing shows the prosecutor outlining his history of skipping court dates and failing to appear despite multiple chances. This isn't a minor slip. It's a long pattern that erodes trust. The prosecutor argues for significant bail, explaining his prior $115,000 warrants and his repeated failures to follow conditions. They note his facing DUI charges from 2021 and 2024, with allegations including a high breath sample and a refusal to test. This isn't just administrative trouble. It's a public safety concern. Valentine objects, blaming clerical errors and claiming confusion about dates. He says he tried to resolve it and even filed letters to the Attorney General's office. But the court sees this as deflection. It's clear he believes writing letters somehow cancels a warrant, ignoring that real legal obligations don't disappear with paperwork. The judge listens but sees through the excuses, recognizing that setting strong bail is necessary to ensure he shows up next time and doesn't endanger the community.
Independently, so you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history, while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So 15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Well, what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District.
Valentine speaks for himself. He launches into full sovereign citizen language, insisting he is not a person or legal entity, but a living man with constitutional rights to travel without a license. He claims the Supreme Court has proven this, though no actual precedent supports that idea. He demands a prosecutor show a contract justifying jurisdiction, calling the court a nice high priest court while trying to invoke Rule N. This is classic pseudo-legal word salad. The judge responds calmly, explaining that nice high priest simply refers to the trial court of original jurisdiction. It doesn't strip the court's authority. Sovereign citizens often misuse these Latin phrases, hoping it sounds authoritative, but courts don't play along. The judge explains that Valentine contracted with the state by driving on public roads, which subject him to licensing and DUI laws. It's a reality check for anyone who thinks chanting legalistic phrases will override actual statutes designed to keep roads.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post.
Offering you Thurston County Public Defense's assistance, I could
deny the right to defend myself. You want me to hire someone?
Despite the court's clear explanations, Valentine keeps pressing, refusing bail conditions, and insisting on his own interpretation of the law. The judge tries to keep things practical, telling him he'll need to post $15,000 cash or bond on each charge, attend pre-trial services within 48 hours of release, and wear a monitoring device to ensure sobriety. These are standard safeguards for repeat DUI defendants. Valentine, however, claims is being coerced and says he has no problem showing up himself, ignoring his history of failures to appear. His argument boils down to denying the court's jurisdiction over him entirely. But the court doesn't accept "I don't consent" as a defense against public safety concerns. The judge highlights that he is not being punished for beliefs, but for actions specifically for allegedly endangering others by driving under the influence. The message is clear. Personal philosophy doesn't exempt anyone from accountability.
Shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah,
I would like
hold on. I'll let you know when I need to hear from you.
okay.
So Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have
Okay,
advised.
well, okay,
He wants
I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you, that's a huge.
The judge rules on bail and conditions. Valentine keeps pushing, asking what jurisdiction the court is operating under. The judge answers plainly. Thurston County District Court, State of Washington. Valentine presses again, asking if it's common law jurisdiction, trying to force the court into admitting some imagined limit to its power. The judge refuses to entertain these semantics. He simply says he has jurisdiction and won't argue it. Sovereign citizens often try to trap judges into admitting their court is illegitimate by playing word games. But judges know better. The court's authority isn't based on Valentine's consent or his approval of its definitions. The judge's patience is notable as he calmly refuses to take the bait, reminding Valentine that he'll be treated as someone proceeding without an attorney, and that means is fully responsible for navigating these legal waters on his own without any special allowances for his beliefs. Next voice. Valentine insists on being swayed jurist, rejecting any label of pro se, even though both mean representing oneself. He then starts grilling the judge about taking an oath to uphold the Constitution. The judge responds that he absolutely has every time he's been elected, and he takes it seriously.
We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing.
Valentine tries to twist it into an argument about whether the judge will honor that oath by letting him bypass state law. The judge explains his upholding the Constitution by enforcing the law equally. This exchange shows the sovereign citizen tactic of reframing constitutional oaths as personal contracts to obey their demands. But courts uphold the Constitution through applying the law fairly, not by granting individuals immunity from it. Valentine's misunderstanding here is profound. He thinks the Constitution frees him from regulation, but in truth it ensures due process, equal application of the law and public safety, all of which the judge is faithfully applying in real time. Next voice as the judge schedules the next hearing. Valentine asks to change the venue for lack of jurisdiction. The judge tells him he'll have to file that motion in writing and serve it on the prosecutor. Valentine complains he can't because he has no resources in jail. No paper, no computer, no printer. The court offers public defense help, but he rejects it, insisting he wants to defend himself while also claiming the system is blocking him. This is a classic contradiction in sovereign citizen logic, demanding total independence while blaming the system for not assisting their unworkable approach. The judge maintains firm but respectful control, explaining the process without bending the rules. He doesn't get drawn into the defendant's frustration or philosophical arguments. Instead, he treats him as any other self-represented defendant expectations and giving him the tools he refuses to use. It's an important lesson in how courts balance rights with practical pairs.
All right, so there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike.
Procedure next voice. Next voice. Valentine continues arguing even after the judge finishes, declaring he doesn't consent to any of the court's orders. The judge simply notes for the record that his consent isn't required. This moment perfectly captures the sovereign citizen. Delusion, thinking they can avoid legal obligation by refusing to agree to it. The law doesn't work that way. The judge calmly explains he will still receive the orders in jail and will be required to comply. Valentine's insistence on rejecting the court's authority has no impact on the court's duty to enforce public safety. The hearing concludes with instructions about pre-trial services and sobriety monitoring. The judge never loses his patience or respect despite the defendant's relentless challenges. This demonstrates how judges have to walk a fine line protecting defendants' rights to be heard.